First, let me thank you for the invitation. It's an honor to be here among you and to present very challenging issue. We come here to celebrate the adoption and the application of the convention. Nevertheless, on the other hand, there's a great opportunity to address also the challenges of this convention, and my contribution approaches one of those challenges. So, how does the European Convention on Human Rights and Fundamental Freedom protect in war? First, little disclaimer. These are my personal views. I'm saying that as a member of International Humanitarian Fact-Finding Commission, and therefore I think it's very important to say these are my personal scientific views, what I'm going to present here. Nevertheless, I think it's okay to say that 10 years ago, the answer to this question would be really short. I would focus on the issue of derogation, then the issue of the ICJ, International Court of Justice, advisory opinions and things like that. Nowadays, the question is much more complicated, because the interaction between not only European but international human rights law and international humanitarian law has got into much more details, and this is going to be the topic of the answer to the question that I got. I'm not going to present into details the cases that are considered within this presentation, because this will be in a written contribution, just to keep the time limit. Nevertheless, the main cases here are Georgia versus Russia, the second one, that has already been decided in relation to merits. The other one, Ukraine and the Netherlands versus Russia, the admissibility decision that was adopted this January, January 2023. And some other cases in Little, Varnava and others versus Turkey, or Hassan versus UK, and some others. What I would like to point out specifically in relation to the first two, the first case considers the situation that happened in 2008 and distinguishes active hostilities that were within these two states during 5 days, 5-day active hostilities. And the second one that considered not the armed conflict of nowadays, but the one that appeared in 2014 in relation to Crimea. So Strasbourg is perfect, nevertheless the time is not its friend. So do not expect the decision on the merits in relation to 2014 case soon, just the admissibility decision. I've chosen 3 particular articles to focus on. The first article, because of the principle of territoriality, extraterritoriality in relation to jurisdiction. And then Article 2 and Article 5, because these 2 articles are perfect examples how the interaction and interplay between human rights law and international humanitarian law might be explained, and where are, I would even say, minds of this relationship about these 2 areas of law. So just to present something that is well known for all of you, the fact that that is the Article 15, focusing on the possibility of derogation from the Convention. Nevertheless, the question is then, what if it is not used by the states? As you know, there is second paragraph within the article that there is no derogation from Article 2, except in respect of death resulting from lawful acts of war, and other articles possible. So what that actually means in application of Convention, we will discuss today when we discuss Article 2 application. And then what I mentioned at the beginning, that we do have advisory opinions of the International Court of Justice that explain in its advisory opinions in nuclear weapon case and war case that international humanitarian law is lex specialis in relation to lex generali, human rights law. Nevertheless, that as if implicitly meant that there was a conflict among these two areas of law. However, my intention for today is to point out how to make these two areas of law coexist. And how to do that? Well, the European Convention on Human Rights is an international treaty, so what about looking at the Vienna Convention on the Law of Treaties? It's Article 31, General Rule of Interpretation. Within the third paragraph, let us see, we do have an explanation what might be and should be taken into consideration when context is considered within general rule of interpretation. You know that text, context, object, purpose, and good faith within application. And we do have explicitly stated that any relevant rules of international law applicable in the relations between the parties to the conflict of the interpretation should be taken into account. And that's exactly the case within armed conflict, international armed conflict. We do have Geneva and Hague Conventions. We do have international humanitarian law rules. For example, in Luzidu case, no, despite the fact of occupation, there was no international humanitarian law rule mentioned. On the other hand, later on, in Varnava case that I mentioned at the beginning, already it was mentioned by Strasbourg that Geneva Conventions are applicable, so it was mentioned there. And as for Hassan case, it was focused on the fact that these two areas of law might and should coexist within application by Strasbourg Court. If we look at that relationship between human rights law and international humanitarian law, if I ask the question, my students, it might be pretty clearly said, well, what is quelle est la raison d'être of these two areas? It means, why do we actually have these areas of law regulating relations among states? I think that the ultimate goal of both areas is the well-being of an individual, despite the fact that the definition for international humanitarian law is regulation of means and rules of warfare. The fact why we regulate conduct is to protect the victims of armed conflicts. And that's exactly the aim why we do have human rights law, to protect the victims. What that means in practice. According to Article 1 of the Convention, the high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of this Convention. We almost already know that by heart. General rule is the territorial jurisdiction of states. Nevertheless, especially in relation to human rights treaties, we do have a rule of extraterritoriality. The issue might raise, what about extraterritoriality in relation to jus in bello? And then the challenge is coming. Because in those two interstate cases that I introduced at the beginning, that's the point that now it has been submitted by Ukraine. If there is a violation of jus ad bellum that might influence, according to Ukraine, it influences application and possibility of declaration of violation also of human rights issues, so the convention. It intrudes the principle of international humanitarian law in relation to jus in bello, especially in relation to belligerent equality. I understand the hunger for humanization also of international humanitarian law. Nevertheless, I think that there are other issues that not only Strasbourg should take into account. What has been decided so far, you might remember even Bankovic case, when the air bombing was considered not to be effective enough. So nowadays we do require effective control over the certain territory to claim extraterritoriality as a basis for jurisdiction. It's not only spatial, it might be also personal. Nevertheless, this is well-based rule. Nevertheless, as for active hostilities, there's the challenge. Is it possible during that chaos to claim and to prove effective control? There are several ways how to answer the question. The question has been distinguished in the Georgia-Russian case too, in relation to the time of after the termination of hostilities, and that time of 5-day active hostilities. So for those 5 days, effective control of Russia was not declared. Nevertheless, it does not concern the procedural obligation, positive obligation of a state to check whether everything was in accordance with the rule of law. I'd like to point out 2 possible ways how to approach this first challenge of Article 1. In relation to state-state case, where we do have horizontal relationship, it might be decided that the prohibition or the violation of jus ad bellum law might be a reason to declare violation of human rights law. Nevertheless, as for individual cases, that is not the case, because international humanitarian law is based on the relations among states. Now, I'm losing the time maybe, so just to speed up to make sure that my personal promise that I finish till 19 minutes will be held. I'd like to move to Article 2, right to life. However sad it is, war, armed conflict, whatever the name is not prohibited by law, by international law. And I'm going to declare that fighting that includes killing is a natural part of hostilities. That, of course, includes the distinction about killing combatants or killing civilians, killing people hors de combat. On the other hand, we do have a completely different approach to protection of right to life within human rights law. I've mentioned Article 15 and the issue of lawful effect of war. Nevertheless, within Article 2, if there is no derogation, we do have the condition, the requirement of absolute necessity. That is another way how to distinguish different levels of proportionality within Strasbourg judiciary. So how could we somehow synthesize those 2 approaches that seem to be so different? Something like killing, if the act of war is lawful, is all right, and then killing, no, if it's not absolutely necessary, the use of force. And the exceptions within Article 2, they do not include the issues of acts of war. Article 2 as such is for, let's call it like peaceful times. There I would go again for Vienna Convention on the Law of Treaties, Article 31, paragraph 3, letter C. And I would apply other international rules that are applicable among states. If we would like to somehow solve that conflict, I think it is very interesting to realize that the principles of these 2 areas are similar. For example, there are many experts here for international humanitarian law. I'm going to mention only 3 basic principles, fundamental principles of international humanitarian law: principle of distinction, principle of proportionality, and the principle of precaution. So as for the principle of distinction, it is there within human rights law as well, because you decide the courts, they decide the cases one by one. The distinction principle within international humanitarian law concerns the groups, combatants and civilians. Nevertheless, the distinction is always there. The proportionality I've already mentioned. It means the absolutely necessary conditions within Article 2, or the proportionality in relation to precaution principle within the preparation of act of war so that it could be declared lawful. So these are the principles that might be helpful even for the Human Rights Court to decide whether a certain act might be considered in accordance with the convention or not, especially in relation to precaution principle, if the procedural safeguards are taken into account. It was especially after McCain versus UK case, when positive obligations of the state, especially in relation to the protection of right to life, was introduced into Strasbourg judiciary. So that for Article 2. Article 5 is a little bit more complicated. It includes right to liberty. I'm not going to read it through. That's just a second part of the first paragraph. No one shall be deprived of his liberty save in the following cases and in accordance with the procedure prescribed by law. And you do have a list, exhaustive list. International humanitarian exception is not there. And even more, in the following paragraphs, you do have the focus of promptness, speediness, and the factor of judge decision. That's not the rule of international humanitarian law if you take into account prisoners of war. You could be a prisoner of war. It means that your right to liberty by detention as a prisoner of war might be really for a very long time. And that's one of the issues of Ukraine position. Because in relation to internment of prisoners of war, you do have constraints of the Article 5 that are not foreseen in the Article 5. But it is very important, again, taking into account that Article 31 of the Vienna Convention on the Law Treaties, the prisoners of war are not punished by detention. They are considered to be a threat to security of the party to the conflict. And that's the reason why their position is different. And I think, that's my personal view, that should be taken into account by the Human Rights Court as well. Moreover, as for procedural safeguards, the decision and the framework as such, it's not an arbitrary decision. One of the Geneva Conventions is whole, and it is very detailed, devoted to the protection of prisoners of war. So you do have a detailed framework for the substance for all those rights of prisoners of war, and moreover, you do have also procedural safeguards concerning the time. You don't know exact time, but you do have at least the end of war. And the reasoning is there within international humanitarian law. That's why I think that Article 31, paragraph 3, letter C of the Vienna Convention on the Law of Treaties is a very helpful tool to synthesize those two areas of international law. I think, and I hope, that the Strasbourg Court in the Mary decision in relation to Ukrainian and the Dutch application against Russian Federation for 2014 conflict will not apply mechanically none of these rules, because there are some statements of the court and there are some statements of judges within dissenting opinions that point out that the application of international humanitarian law is considered in a different way as it was as it is understandable within international humanitarian law as such. if we compare just why not to apply it mechanically, because international humanitarian law, it is universally applied, of course. Even other regional systems, it's not only the issue for the European regional system, but also for African and Inter-American, and even the Human Rights Committee has already adopted and published general comment on the issue, and not always grabbed it correctly. So it is very dangerous to mechanically apply rules of one area of law to a situation that has been created with a specific situation of armed conflict. Moreover, as for international humanitarian law, you do need a very good fact-finding that might be resolved, for example, by amicus curiae that has already been provided, not only to Strasbourg. And finally, of course, as always, it is a judicial body, but there are always some political issues to be decided. So just to answer the question, how does the Convention protect human rights in war? It does. It depends on the parties to the conflict of war, if I use this word. Nevertheless, I think that there is still quite a huge road for the court to understand the interaction between human rights law and international humanitarian law, and what might be useful, Article 31, to understand the context and to decide, especially if an individual is there, case-by-case cases. As for interstate cases, the decision might be different because international humanitarian law covers relations among states as well. So thank you for your attention. I look forward to any questions, and I do have one whether I have kept the limit.
Sure.
Thank you.